Islam, Islam, Islam nobles. I'm Menelik Ibrahim Brown L, and I'm here today to talk to you nobles. And I'm gonna be pertaining this discussion on International Court of Justice, year 1952, August 27th, 1952, case concerning the rights of nationals of the United States of America in Morocco, France versus United States of America. Um, Economic liberty without any inequity in Morocco and the General Act of Algiers, right? So, in the General Act of Algiers, and in that act, okay, we're going to go to the Treaty of Peace and Friendship between the United States and the Bey and subjects of Tripoli of Barbary. Okay, authored by American diplomat Joel Barlow in 1796. The following treaty was sent to the floor of the Senate on June 7th, 1797. Okay, where it was read aloud in its entirety and unanimously approved. John Adams, having seen the treaty, signed it and proudly proclaimed it to the nation. Okay, Article 1, and this is Annals of the Congress of Fifth Congress. Article 1, there is a firm and perpetual peace and friendship between the United States of America and the Bey and subjects of Tripoli, Barbary, made by the free consent of both parties and guaranteed by the most potent Dey and Regency of Algiers. Okay, so Algiers again, Algiers. Okay, effect of the establishment of a protectorate therein, effect of discrimination on validity of residential decree of December 30th, 1948, regulated imports, consular jurisdiction in French zone of Morocco as based on bilateral, right, treaties, most favored nation clause, and multilateral treaties. Okay, multilateral treaties, meaning of dispute and treaty of 1836 between Morocco and the United States. The United States renunciation, you see, between Morocco and the United States, whether applicable to criminal and civil matters, effect of renunciation by other states of consular jurisdiction, effect of Convention of Madrid and Act of Algiers on consular jurisdiction, custom and usage, right of absent, right, to Morocco legislation as corollary of consular jurisdiction, assent necessary for application of Morocco laws in consular courts, local laws contrary to treaty rights. So now there's a high debate on consular courts. Now, consular courts supposed to be in the jurisdiction of the United Nations and the League of Nations before they shut the League of Nations down. Okay, and that was in the party of that doing so within United States corporations relinquishing their jurisdiction as far as having meetings for nationals here in the United States of America, which is the Empire of Morocco. They wanted to sever ties, but still hold the jurisdictional ties. Okay, so so that's what it says right here: dispute in the Treaty of 1836 between Morocco and the United States, whether applicable to criminal and civil matters. Okay, so they didn't want to be applicable, okay, to civil matters. All right, okay. So that's why they wanted to do the certain thing that they did as far as the Act of Algiers' effective establishment of the protectorate thereon, effect of discrimination on the fidelity of residential decree of December 30th, 1948, regulating imports. Okay. Consular jurisdiction in French zone of Morocco as based on bilateral treaties was treaties most favored nation clauses and multilateral treaties, meaning of dispute in treaty of 1836 between Morocco and the United States, whether applicable to criminal and civil matters, effect of renunciation by other states of consular jurisdictions, effect of Convention of Madrid and Act of Algiers on consular jurisdiction, custom and usage. Okay, right of assent to Morocco legislation as corollary of consular jurisdiction, assent necessary for application of Morocco laws in consular courts, local laws contrary to treaty rights. See, local laws are contrary to treaty rights. That means that the local laws do not even apply when treaties are, because the treaty subjugate any of those bull crap laws. You see what I'm saying when it comes to rights of Moors. So now fiscal immunity as based on Convention of Madrid and Act of Algiers and Most Favored Nation Clause. Interpretation of Article 95 of Act of Algiers. Now we're going to stop right there. We're going to go back to the Treaty of Algiers, right? Which these people be predicating that Moors don't have treaties with these people, and how they set up a fake treaty, okay, which was done by the hybrids within the conformity of them trying to be us. You see what I'm saying? So they make these treaties, they relinquish the jurisdiction of nationals being Moroccans and having their nationalities here in the so-called United States corporation. Okay, because it says here it goes right here. Annals of Congress, Fifth Congress, Article 1, there is a firm and perpetual peace and friendship between the United States of America and the Bay, and subjects of Tripoli. So, that means subjects of Tripoli, Morocco, all Moors, okay, and all territories, okay, that was here, as Moors in different states, as far as we know as countries. So it says the Bay and subjects of Tripoli of Barbary, made by the free consent of both parties and guaranteed by the most potent Dey and Regency of Algiers, right? So if any goods belonging to any nation with which either of the parties is at war, okay, shall be loaded on board of vessels belonging to the other party, they shall pass free, and no attempt shall be made to take or detain them. Article 3, if any citizen, subject, or effects belonging to either party shall be founded on board a prize vessel taken from an enemy by the other party, such citizens or subjects shall be set at liberty and the effects restored to the owners. Okay. Proper passports are to be given to all vessels of both parties by which they are to be known. And considering the distance between the two countries, 18 months from the date of this treaty shall be allowed for procuring such passports. During this interval, the other papers belonging to such vessels shall be sufficient for their protection. Okay, so when Moors go and claim their nationality, whatever protections whatever paperwork they went to go afford their rights to their protections, it's allowed, because you are proclaiming to who you are, and that's in your treaties. Okay, And that's Article 4. Then you got Article 5. A citizen or subject of either party having brought a prize vessel condemned by the other party or by any other nation, the certificates of condemnation and bill of sale shall be sufficient passport for such vessel for 1 year, this being a reasonable time for her or him to procure a proper passport. Article 6, vessels of either party putting into ports of the other and having need of provisions or other supplies that shall be furnished at the market price, and if any such vessel shall to put in from a disaster at sea and have occasion to repair, she shall be at liberty to land and re-embark her cargo without paying any duties, but in case shall she be compelled to the land her cargo. Article 7, should a vessel or either party be cast on the shore of the other, all proper assistance shall be given to her and her people. No pillage shall be allowed. The property shall remain at the disposition of the owners and the crew, protected land subscored till they can be sent to their country. If a vessel of either party should be attacked by an enemy within gunshot of the force of the other, she shall be defended as much as possible. If she be in port, she shall not be seized on or attacked when it is in the power of the other party to protect her. And when she proceed to sea, no enemy shall be allowed to pursue her from the sea or from the same port within 24 hours after her departure. Article 9, the commerce between the United States and Tripoli, the protection to be given to merchants, masters of vessels, and seamen, the reciprocal right of the establishing councils in each country, and the privileges, immunities, and jurisdictions to be on the same footing with those of the most favored nations, respectively. Article 10, the money and presents demanded by the Bey of Tripoli as a full and satisfactory consideration on his part and on the part of his subjects for this treaty of perpetual peace and friendship are acknowledged to have been received by him. Okay. Received by him previously to his signing the same according to a receipt which is hereto annexed, except such as part as and promised on the part of the United States to be delivered and paid by them on the arrival of their consul in Tripoli, of which part a note is likewise hereto annexed, and no pretense of any periodical tribute or further payments is ever to be made by either party. Okay? Now, Article 11, as the government of the United States of America is not in any sense founded on the Christian religion, as it has in itself no character of enmity against the laws, religion, or tranquility of Mussulmen, and as the said states never entered into any war or act of hostility against any Mohammedan nation, it is declared by the parties that no pretext arising from religious opinion shall ever produce an interpretation of the harmony existing between the two countries. So the harmony of the nations are between two countries. It's two countries, right? That is the European nations, and then you have the Moor nations. Okay, the Moor nations, the European nations are here both on this landmass. Okay, all right. So in case of any dispute arising from a violation of any of the articles of this treaty, no appeal shall be made to arms, nor shall war be declared on any pretext whatever. But if the council residing at the place where the dispute shall happen shall not be able, right, to settle the same, and a mimical reference shall be made to the mutual friend of the parties, the days of Algiers, the parties hereby engaging to abide by his decision, and he by virtue of his signature to this treaty engages for himself and successors to declare the justice of the case according to the true interpretation of the treaty, and to use all the means in his power to enforce the observance of the same. Signed and sealed at Tripoli of Barbary, the third day of Janat in the year of the Hajira, 1211, corresponding with the fourth day of November, 1796, by Joseph Bashar Muhammad Bey. Muhammad Treasurer, Ahmad Minister Amari, Solomon Kaya. Okay, so that is the treaty of peace and friendship between the United States and the Bey subjects of Tripoli and Barbary. Okay, so now that was the article's interpretation of Act of Algiers. Now you have the judgment of 852 U.S. nationals in Morocco, and the case concerning the rights of nationals of the United States of America in Morocco. So that means that these people made treaties with, that Moroccans from the kingdom can come back and forth here as, a party with citizenship, just as granted like any American citizen will have. You see what I'm saying? So the Moroccan kingdom will have trade, commerce, and peace and friendship, and we'll be able to go into each other's jurisdictions without any flaws, right? So in the case of the rights of nationals of the United States of America and Morocco between the French Republic, represented by M. Andrew and Andre Gross, professor of the Facilities of Law, legal advisor to the Ministry for Foreign Affairs, as agent, assisted by M. Paul Ruder, professor of the Facility of Law of Axon, Providence, assistant legal advisor to the Ministry of Foreign Affairs as assistant agent, and by M. Henry McCack, minister plenipotentiary as counsel, and by M.D. Levine, inspector des finances, M. Ford Marie des Requêtes Conseil d'État, and M.D. La Bardieri, professor of the Facilities of Law, as expert advisors, and the United States of America, represented by Mr. Adrian S. Fisher, the legal advisor, Department of State, as agent, assisted by M. Joseph M. Sweeney, assistant of the legal advisor, Department of State. Then we have Mr. Salem Moore J. Rubin, member of the Bar of the District of Columbia, right, as counsel. So that's why you have the District of Columbia as still part of the representation of Morocco, because these people, they went and did a treaty, okay, without the Moors, all right, after the fact, because let's see, when the Prophet came back, and that was in the 1900s when he was running around, he set certain standards for Morocco and the Moors and stuff like that. And when he got betrayed by Moors from here and Masons and stuff like that, they hurry up and try to usurp and hide what the Prophet did. So we're gonna just look at it like this. Now, before the Prophet even get here, they was doing certain things and council to secure certain things for their members. You see what I'm saying? So when the Prophet came, they was kind of like, damn, I thought these Moors were never going to wake up. So he had to come in and bring in a divine intervention and open up the gates for Moors, because at one particular point in time, we didn't know. If it wasn't for the Prophet Noble Drew Ali, all honors and respect to our universal prophet, and illustrious prophet, we'll probably still be in the same mental state. So you had M. Sayer Moore, J. Rubin, member of the Bar of the District of Columbia, as counsel, and by Mr. John A. Bovary Jr., Counsel, United States Consulate General, Casablanca. So they got Casablanca, Mr. John A. Bovary Jr., Counsel, United States Consulate General, Casablanca. Okay. Then judgment of the 27 852 U.S. nationals in Morocco. Mr. Edwin L. Smith, legal advisor, United States litigation, Tangier. Okay. Then you have Mr. John E. Utter, first Secretary of the United States Embassy, Paris. See, you got all this legislation. You got people in Paris from the United States. You have people who got legislation from Tangier, right? As expert advisors. The court composed as above delivers the following judgment on October 28th, 1950. Now, this is after the prophet, okay? After the prophet. He been here. He proclaimed who we were. He set up the Moorish science temples and everything. So after the prophet demise, they changed everything up, right? They try to say that the prophet didn't bring Islam here. He didn't teach civics. He didn't enforce laws. He didn't talk sovereignty. He didn't talk nationality, which all of these are lies because he did. This is the scope of how our people take information and do they really go and check behind the information once it's been uttered, once it's been given out? Do they do their own due diligence? Because if they don't, and if they go with the narrative, then they'll never get out of the mental slavery. Okay? So that's why, as far as us being in our proper person, we always have to look at certain things for what they are. And if we don't look at things for what they are, then we'll never get anything done. You see what I'm saying? Because we'll always be waiting on somebody to do them for us. So that's what we're trying to not get into a habit of doing. On October 28th, 1950, right, the Charge d'Affaires AI of France to the Netherlands filed in the registry on behalf of the government of the French Republic and an application instituting proceedings before the court against the United States of America concerning the rights of nationals of the United States of America in Morocco, right? The application referred to the declarations by which the government of the United States of America and the French government accept the compulsory jurisdiction of the court in accordance with Article 36, Paragraph 2 of the court statute. It also referred to the Economic Cooperation Agreement of June 28, 1948, between the United States and France, and to the Treaty for the Organization of the French Protectorate in the Sharifan Empire. So the United States made a treaty after the prophet came with de facto hybrids to usurp the Moors' nationality. It's all it's treason. It's treason. That's what it is. It's treason. And that's just what it is. I don't have time for people doing treason with Moorish nationality. Okay? And that's exactly what's going on right here, because it says, United States of America, the French government accepted the compulsory jurisdiction of the court in accordance with Article 36, Paragraph 2 of the court statute. It also referred to the Economic Cooperation Agreement of June 28, 1948, between the United States and France, and to the Treaty for the Organization of the French Protectorate in the Sharifian Empire, signed at Fez on March 30th, right, 1912, between France and the Sharifian Empire. Okay, so wait a minute. Okay, somebody is lying here. Now, with Article 36, Paragraph 2 of the court statute, it also referred to the Economic Cooperation Agreement on June 28, 1948, right, between the United States and France, and to the Treaty for the Organization of the French Protectorate in the Sharifian Empire, signed at Fez on March 30th, 1912, between France and the Sharifian Empire. It mentioned the Treaty of Peace and Friendship of September 16, 1836, between the United States and the Sharifian Empire, as well as the General Act of the International Conference of Algiers of April 7th of 1906. So, pursuant to Article 40, Paragraph 2 and 3 of the statute, the application was communicated to the government of the United States as well as to the states entitled to appear before the court. It was also transmitted to the Secretary General of the United Nations. The time limits for the deposit of the pleadings were fixed by order of November 22nd, 1950, the memorial of the French government. See, that's after the Prophet. That's after the Prophet demise. And then they say they did all this in between 1912, right? They couldn't have done that between 1912 unless a dirty Moor did it, because that's when the Prophet was running around. So how all these treaties are enacted with one that was only in 1912? So who signed that treaty who did that in 1912? The Prophet was running around. So you have all this conspiracy that's going on right now with these acts of treason. Then you have, the parties between thus in question such states were notified in accordance with Article 63, Paragraph 1 of the statute. For this purpose, notes were addressed on April 6, 1951 to the governments of Belgium, Spain, Italy, the Netherlands, Portugal, the United Kingdom of Great Britain, and North Ireland and Sweden, which all Moors have treaties with. Okay, which we already know. On June 21st, 1951, with the time limit fixed for the deposit of its counter memorial, the government of the United States of America filed a document entitled Preliminary Objection. The proceedings of the merits were thereby suspended. The primary objection was communicated to the states entitled to appear before the court, as well as to the states which had been notified of the deposit of the application pursuant to Article 63 of the statute. Okay. The proceedings thus instituted by the primary objection were terminated following a declaration by the government of the United States that it was prepared to withdraw its objection, having regard to the explanations and clarifications given on behalf of the French government, and following declaration by the French government that it did not oppose the withdrawal, an order of October 31st. So that sounds like a conspiracy that they want to control with the French Moroccans, right? Which are Moors, because they were Huguenots. Moors were French people too, and the protectorate was Morocco. Morocco was protecting the French. They got to understand that the French people was over here. Okay, so they what they did was they gave them the kingdom, put it over there in Africa. You see what I'm saying? And most of those people over there are hybrid Moors. Like, they come from over here too, because that's what the whole dispute was about. Okay, now you have, now states that is prepared to withdraw its objection, having regard to the explanation and clarification given on behalf of the French government and the following declaration by the French government that it did not oppose the withdrawal. An order of the October 31st, 1951, placed on record the discontinuance record that the Proceedings on the merits were resumed and fixed new time limits for the filing of the counter memorial reply and rejoined. The counter memorial reply were filed within the time limits thus fixed. As regarded the rejoinder, the time limit was extended at the request of the government of the United States from April 11th to April 18th, 1952, by order of March 31st, 1952. Okay. On April 18th, 1952, the rejoinder was filed and the case was readily for hearing. Public hearings were held on July 15th, 16th, 17th, 21st, 22nd, 23rd, 24th, and 26th of 1952, during which the court heard Eminem, Andrew Gross, and Paul Rutner on behalf of the French government, and Mr. Adam F. Fisher and Mr. Joseph M. Sweeney on behalf of the government of the United States. At the conclusion of the argument before the court, the submissions of the parties were presented as follows. On behalf of the French government, may it please the court to adjudge and declare that the privileges of the nationals of the United States of America in Morocco are only those which result from the text of Articles 20 and 21 of the treaty. Articles 20 and 21 of the Treaty of September 16, 1836, and that since the most favored nation clause contained in Article 24 of the said treaty can no longer be invoked by the United States in the present state of the international obligations of the Sharifian Empire, there is nothing to justify the granting to the nationals of the United States of preferential treatment, which would be contrary to the provisions of the treaties. So that means that Americans, right, who call themselves Americans, you have to be Moorish Americans. You have to be more American. You cannot be a white American trying to participate in Moorish treaties because you're not a Moor. Those treaties only apply to Moors who have birthrights. Okay, so and that's why the favor clause was taken off the board. But they try to make it like that was only for United States citizens. No, that's for Moors. The favored nation clause is for Moors, not for them. Okay, so and the Sharifian Empire. So if they talking about the Sharifian Empire, who's running the Sharifian Empire? Is that the world national movement? Because that's the only Sharifian Empire I know of Moors, really. Is the Moorish National and Divine Movement that the Prophet has set up. So, and he said that we were sheik. So, what other Sharifian is y'all talking about? Because it says right here, most favored nation clause contained in Article 24 of the said treaty can no longer be invoked by the United States in the present state of the international obligation of the Sharifian Empire. There is nothing to justify the granting to the nationals of the United States of preferential treatment, which would be contrary to the provisions of the treaties. That the government of the United States of America is not entitled to claim that the application of all laws, right, of all laws and regulations to its nationals in Morocco requires it express consent. That the nationals of the United States of America and Morocco are subject to the laws and regulations enforced in the Sharifian Empire, and in particular the regulations of December 30 of 1948 on imports not involving an allocation of currency, right, without the prior consent of the United States government. So now they're trying to, make sure that you got to go through them before you can do anything. So that's why the United States is usurping the Moorish sovereignty. Okay, that the decree of December 30 of 1948 concerning the regulations of imports not involving an allocation of currency is in conformity with the economic system which is applicable to Morocco, according to the conventions which bind France and the United States. That Article 95 of the Act of Algiers defines value for custom purposes as the value of the merchandise at the time and at the place where it is presented for custom clearance. That no treaty has conferred on the United States fiscal immunity, right, for its nationals in Morocco, either directly or through the effect of the most favored nation clause. That the laws and regulations of fiscal matters which have been put into force in the Sharifan Empire are applicable to the nationals of the United States without the prior consent of the government of the United States. See, you see that, Morris? You see that? Like, you don't have to go ask the United States for none of this. You already have the right because the prophet already set that up. You don't have to go ask them permission once you already declare your nationality. Okay, all right? Because you're supposed to enforce those laws, okay? Prior consent of the government of the United States. That consequently, consumption taxes provided by the Dahar of February 28, 1948 have been legally collected from the nationals of the United States and should not be refunded to them. So, what? That consequently, consumption taxes provided by the DAR of February 28, 1948 have been legally collected from the nationals of the United States and should not be refunded to them on behalf of the government of the United States. The submissions and conclusions presented by the French government in the case should be rejected on the ground that the French government has failed to maintain the burden of proof which it assumed as party plaintiffs, and by reason of the nature of the legal issues involved. The treaty rights of the United States and Morocco forbid Morocco to impose prohibitions on American imports, save those specified by the treaties, and these rights are still in full force and effect. So that's what it's all about: commerce and doing certain commerce with the kingdom. Okay, United States is a major world player of doing commerce with everybody. That's why they got their hands in everything. They're using the Moorish jurisdiction to go certain places to do certain things. Okay, and the treaty rights of the United States and Morocco forbid Morocco to impose prohibitions on American imports, save those specified by the treaties, and these rights are still in force and effect. The Dahar of December 30th, 1948, imposing a prohibition on imports is in direct contravention of the treaty rights of the United States, forbidding prohibitions on American imports, and the French government by applying the Dahar on December 30th, 1948 to American nationals without the consent of the United States. From December 31st, 1948 to May 11, 1949, violating the treaty rights of the United States and was guilty of a breach of international law. So this is what these people do. Okay. States forbidding prohibitions on American imports, and the French government by applying Dahar of December 30th, 1948 to American nationals without the consent of the United States from December 31st to 1948 to May 11, 1949, violated the treaty rights of the United States and was guilty of a breach of international law. American nationals cannot legally be submitted to the Dahar of December 30th, 1948 without the prior consent of the United States, which operates to waive temporary its treaty rights. See, and who says that? Who says that I want to waive my treaty rights? Those treaties was made by Moors, not by United States. So what are they doing? That's why they want to get rid of the council, of course, because then nobody can hold them accountable for the actions that they are doing in our name. Okay, Moors. So that's why that's why Moors have to be very, 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 very up on their game. Okay, because this is what they've been doing. Temporarily is treaty rights. The jurisdiction conferred upon the United States by the treaties of 1787 and 1836 was jurisdiction, civil and criminal, in all cases arising between American citizens. I'm going to say that again. Number 3, the jurisdiction conferred upon the United States by the treaties of 1787 and 1836 was jurisdiction, civil and criminal, in all cases arising between American citizens. In addition, the United States acquired in Morocco jurisdiction in all cases in which an American citizen or protege was defended through the effect of most favored nation clause and through custom and usage. Such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone of Morocco. Now, I'm going to say this again. Jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone of Morocco. So that means the French zone of Morocco and all this right here. French zone of Morocco is Louisiana. Morocco is Indiana. Okay. All right. And Britain is in so-called Canada, which we know it as Canonland. Okay. And this is what they did. They all divvied land. They all divvied up the Moorish powers, and they went and did whatever they wanted to do with them. You see what I'm saying? Because it says in the jurisdiction, its rights of jurisdiction in the French zone of Morocco. So that's why they talk this smack about, oh, that's a French flag. That Moorish flag, that's a French flag. No, it's not. No, it's not. Because what people don't get is that we got treaties with France. We got treaties because everybody was in this jurisdiction, and they all was Moors at one particular point in time. Okay, and we relinquished certain areas and certain jurisdictions to let our children, which is the Yorubas, the modern mankind, take over certain dominions. You see what I'm saying? So such jurisdictions has never been renounced expressly on impededly by the United States, okay, under the regime of extraterritorial jurisdiction now exercised by the United States in Morocco. See, United States citizens are not subject in principle to the application of Moroccan laws. You see, because they are looking at Morocco, and they're looking at the kingdom, the United States of America, and Morocco, the kingdom, as a big empire. And the Europeans don't want to come up under Moroccan or Sharifian law. Okay, they don't want to come up under our laws. That's why they do the certain things they do and relinquish certain jurisdictions here, so we won't be able to enforce our laws upon them. That's why they relinquish the consular courts. Moors are not supposed to be consular courts. No, the Europeans supposed to have the consular courts. We're supposed to come in and do legislation there. So we'll have parties with international and trade agreements and everything like that too, because all the agreements was made through United States corporation, which they in turn usurped and cooled the government. But anyway, back to what I was saying, such laws became applicable to the United States citizens only if they are submitted to the prior asset of the United States government, and if this government agrees to make them applicable to its citizen, the dire of December 30th, 1948, not having been submitted to the prior assent of the United States government, cannot be made applicable to the United States citizen. Okay? All right, Morris? So that's the whole thing, though. Making it applicable. You see? Making things applicable for people to understand them and know and have a better understanding of what has been happening and how Moors have been usurped and how Moors have been duped, and now they want to try to play this sovereign citizenship, okay, and want to call Moors what these Europeans have made up on their own because of the certain provisions that they needed to go against this damn piracy that was going on within our government. Okay, Morris? So what people don't get is that we have to be very, very, very understandable about what's really going on with what's what's really going on. You know what I mean? And as far as anything else, you know, we have to pay major attention to certain things, because if we don't pay major attention to certain things, then we will be duped, Morris. And I don't want us to be duped. That's one thing. That's one thing I don't want us to be, is duped. Okay? So within that, you know what I mean, we have to really, really make sure that things are in its best presentation. Now, under Article 95 of the Act of Algiers, the value of imports from the United States must be determined for the purpose of customs assessments by adding to the purchase value of the imported merchandise in the United States the expensive incidentals to its transportation to the custom house in Morocco, exclusive of all expenses following its delivery to the custom house, such as customs duties and storage fees, is a violation of the Act of Algiers and a breach of international law for the customs authorities to depart from the method of valuation so defined and to determine the value of imported merchandise for customs purposes, but relying on the value of the imported merchandise on the local Moroccan market. The treaties exempt American nationals from taxes, except as specifically provided by the same treaties. To collect taxes from American nationals in violation of the terms of the treaties is a breach of international law. So if that's a breach of international law, right, why are they taxing the Moroccans here? Why are they doing that? I want to know. Okay? Why are they taxing the nationals here on the land? Because they are doing things out of their scope. Okay? The French government, okay, and was, under for so either purpose, to usurp the Moroccan provisions. Okay? Because what people don't understand is that Moroccans, right, which they'll say is French. No. You had nationals, you have Moors that was everywhere. Okay? And you have Moors that was in certain jurisdictions. Okay? All right? And what they don't get is that these jurisdictions was right here. Now, the treaties exempt American nationals from taxes, except as specifically provided by the same treaties to collect taxes from American nationals. So, in violation of the terms of the treaties is a breach of international law. Such taxes can legally be collected from American nationals only with the previous consent of the United States, which operates to waive temporarily as treaty right. So they are in cahoots to usurp the nationals here. Okay? All right? And if you people don't get it, you see what I'm saying, then you'll forever be asleep. Okay? Forever be asleep. Because that's what they're doing. They are usurping from the empire what they set up. They set up the kingdom, okay, which they have a Moroccan jurisdiction there. And from there, they legislate through there, and then they do all type of trade agreements as far as them doing business with each other and keeping the nationals over here without nothing. See what I'm saying? How many times you Moors been to the Kingdom of Morocco? How many times? Like, we're supposed to go there all the time. Like, we should be frequent flyers there going back and forth because they are part of our empire. So if they are part of our empire, we should have access, there, and access to wherever the hell we need to have access to as Moors. But more frauds. The United States government are playing these games with us. Okay, so consumption tax is provided by the Har of February, and that's the kingdom too. It's both of them, because all of these people that's in cahoot. That's the French government. That's the Canadian, so-called Canadian government. That's the United Nations. That's the what is it? England, Britain. Well, they just relinquished Britain. A lot of people are coming out from under them. So, it's a lot of things that these people, that the European unions have conspired against Moors. Okay, which with the help of the Morisco Moors and the Masons, which are of real matter of fact. It's not. It's they bootleggers. They are gatekeepers. Okay, they bootleg all the information and try to make like that information is not real. Then here they go with the SPLCs. Okay, the NAACP. Here they go with all these organizations that's not doing a damn thing for our people, but calling them Negroes, blacks, and colors. Okay, and putting them up under this 28 United States Code. Color of law, Black Christian Code. That's what they're doing. And then they want to beat up Moors and try to talk smack about Moors. You see what I'm saying? Which, it's not even necessary. Not even necessary, but it is necessary because they have to put up this charade, okay, and keep people in a certain light. Keep them in the dark. Don't bring them into the light. Keep them in the dark. Then they want to go with these slanderous titles. Okay, calling people sovereign citizens and shit. You cannot call a Moorish American a sovereign citizen. I'm sorry. That's oxymoron. And all these temples that's saying so, or saying or calling Moors sovereign citizens, they need to be held for treason too. The cat is out of the bag. Your rents due, mother effers. Your rents due. Don't try that falling down the stairs shit. Your rents due. Okay? And you have to pay more off a compound interest, just like the prophet said. Okay? Okay? Now, the court will first deal with the dispute relating to the decree issued by the resident general of the French Republic in Morocco, dated December 30th, 1948, concerning the regulation of imports. Now, see, this is all the divvying up of the money and all the Moorish resources. Okay, then you have U.S. nationals in Morocco into the French zone of Morocco, which is Louisiana, right? Which is the parishes. Okay, the following submissions are presented on behalf of the government of France, that the decree of December 30th, 1948 concerning the regulation of imports not involving an allocation of currency is in conformity with the economic system which is applicable to Morocco according to the conventions which bind France and the United States. Okay? Okay? So no matter how you look at it, it's going to bind the United States and France, which is Louisiana before they took France and moved it all the way over there. Okay? Now, and his rights are still in full effect. So if you don't know your rights and these people are usurping your rights and they using them for themselves and calling themselves American nationals, okay? Well then, somebody has to be paid. Somebody has to pay for treason and lying. The French government contends that the decree of December 30th, 1948 is in conformity with the treaty provisions which are applicable to Morocco and binding it on France and the United States. The contention is disputed by the United States government for various reasons. The court will first consider the claim that the decree involves a discrimination in favor of France, which contravenes the treaty rights of the United States. By a dare of September 9, 1939. His Sharifian Majesty decided as follows. Okay. Okay, this is in 1939 after the Prophet now. So who's running this shit? Who's the Sharif Mesh? Okay, Article 1. It is prohibited to import into the French zone of the Sharifan Empire, whatever may be the customs regulations, enforce goods other than gold in any form. Article 2. The Director General of Communications may, however, waive this prohibition on entry as regard combustible, solid, mineral matter, and petroleum products, and the Director of Economic Affairs may be likewise as regard any other products. Article 3. It is left to the decision of the Resident General to determine the measures whereby the provisions herein contained shall be put into effect. A residential decree of the same date laid down the terms of application of the DAR, including provisions relating to requests for a waiver of the prohibition in imports. Okay, the prohibition imports. Article 4 provided goods of French or Algerian origin origin shipped from France or Algeria shall for the time being be admitted without any special formalities. Further regulations were prescribed by a residential decree of September 10th, 1939, subjecting imports without official allocation. Okay. So, of currency to special authorization, Article 7 provided in its first paragraph commercial agreements with France, Algeria, French colonies, African territories under French mandate, and Tunisia are not subject to the provisions hereon, right? So, okay, by a residential decree of March 11th, 1948, a new Article 5 was added to the decree of September 9th, 1939. So why would they add another decree? Why would they do that? Why would they do that, Morris? Because they're usurping your shit. They're usurping what the Prophet did. Okay. Then you have French Union. Okay, look. French zone of the Sharifan Empire, France, or any territory of the French Union on the part of the foreign territory of the other part. Finally, this new Article 5 revoked by the decree of December 30th, 1948, which is the subject matter of the present dispute. After having preferred to DAR of September 9th, 1939, and to the decrees of that date and of March 11, 1948, and the Resident General of French Republic decree. Article 1. The provision of Article 5 of the aforesaid residential decree of September 9th, 1939 will cease to apply as from January 1st, 1949, save for exception set out in Article 2 hereof. Article 2. Goods which are proved to have been shipped directly to the French zone of the Sharifan Empire before January 15, 1949 shall still fall within the provisions of Article 5 of the aforesaid residential decree. Okay? All right? Of September 9th, 1939. The effect of this decree was to restore the import regulations introduced in September 1939 points without official allocation. Without official allocation of currency were again subjected to a system of license control. But these import regulations did not apply to France or other parts of the French Union. From France and other parts of the French Union, imports into the French zone of Morocco were free. So, see, the French zone of Morocco. See how the French have a zone of Morocco? But people keep trying to say, oh, that's a French Moroccan flag. That's from that Moroccan. That's a French name. And this is that in the third. You idiots. All this shit is fraudulent that they did. Okay? Fraudulent. Because they did it after the fact, after the Prophet demise. Now, controversy that is treaty rights. It is common ground between the parties that the characteristics of the status of Morocco as resulting from the General Act of Algiers of April 7th, 1906 is respect for the three principles stated in the preamble of the act, namely the sovereignty and independence of His Majesty the Sultan, the integrity of his domains, and economic liberty without any inequity, right? The last mentioned principle of economic liberty without any inequity must in its judgment of 27th of 852 U.S. nationals in Morocco. Okay. Application to Morocco be considered against the background of the treaty provisions relating to the trade and equity of the treatment in economic matters existing at that time by the Treaty of Commerce with Great Britain of December 9th, 1856, as well as by the treaties with Spain of November 20th of 1861 and with Germany of June 1st, 1890. The Sultan of Morocco guarantees certain rights in matters of trade, including to Morocco. These states, together with a number of other states. Now, this is all before. This is all before. This is the Morocco over here, okay? Because Morocco wasn't recognized. The kingdom wasn't recognized until 1957. Okay. Everything was recognized after the fact. The kingdom was recognized in 1957. So what Morocco these people are talking about? So this is in the United States Congress. It's their record of what they got on file. Okay. And then, this is everything that they did as far as, the favorization clause. Okay. See, look, it says right here, by the Treaty of Commerce with Great Britain of December 9th, 1856, as well as the treaties with Spain on November 20th, 1861, and with Germany of June 1st, 1890, the Sultan of Morocco guaranteed certain rights in matters of trade. I said that already, including imports into Morocco. These states, together with a number of other states, including the United States, will guarantee equity of treatment. Okay? No, that's equality of treatment. My bad. Okay? By virtue of most favored nation clauses in their treaties with Morocco. On the eve of the Algiers Conference, the three principles mentioned above, including the principles of economic liberty, without any inequality, were expressly accepted by the France and Germany, right? In an exchange of letters of July 8th, 1905, concerning their attitude with regard to Morocco. This principle, this is when they're selling us out. This is in 1906. This is when the flag gets put away. Okay. All right. So who's running Morocco? The United States is running Morocco. Okay. Moorish is still being recognized over here. All right. But they hide certain things when the prophet did certain things. So July 8th, 1905, concerning their attitude with regard to Morocco, this principle in its application to Morocco was thus already well established when it was reaffirmed by that conference and inserted in the preamble of the Act of 1906. Considered in the light of these circumstances, it seemed clear that the principle was intended to be of a binding character and not merely an empty phrase. This was confirmed by Article 105, where the principle was expressly applied in relation to the public services in Morocco. It was also confirmed by declarations made at the conference by the representative of Spain, who referred to the equality of treatment in commercial matters, as well as by the representative of France. See? The establishment of the French protectorate over Morocco, right? Now, see, this is what I'm talking about, right here. So those people that's over there in the kingdom, those are not real Moroccans. They have mixed with Moroccan descent and French people, French Moors. Oh, okay. Now, it says commercial matters as well by the representative of France. The establishment, I'm going to read it again. The establishment of the French protectorate over Morocco by the Treaty of March 30th, 1912 between France and Morocco. So who did this? Who did this treaty in 1912? Was the prophet was running around? Okay. Okay. November 4th, 1911, concerning the establishment of this protectorate, the government of Germany made in Article 1 the reservation, right, that the action of France should secure in Morocco economic equality between the nations. On the other hand, the government of France declared in Article 4 that it would use its good offices with the Moroccan government in order to prevent any differential treatment of the subject of the various powers. So look at there, Morris. So if anybody talking this goddamn Moroccan is a French name and all this shit, they liars. They liars, Morris. They're straight up liars because these fools don't know what the hell they're talking about. Our flag is over 10,000 years old. It's over 50,000 years old. Huh? Damn dummies. So for those are for the people that, you know, who said all these preposterous things. You know what I mean? I'm not trying to, you know, insult anybody's intelligence, but I'm just saying, you know what I mean? Moors have to deal with a lot of things when it comes to being a Moor. And how these people are twisting what the prophet brought and saying the prophet didn't bring this, but in actuality he brought everything and he was right, period. Okay, so if all these second guessing Moors that's running around here keeping Moors in a mental state of slavery, then they need to be punished for that. And I hope Allah meets them gravely with that action, quick like and swiftly. But yeah. So the other states on behalf of which the Act of Algiers, right, was signed with the exception of the United States, adhered later to the Franco-German Convention of 1911, thereby again accepting the principle of equity of treatment in economic matters in Morocco. France endeavored to obtain also the adherence of the United States, and in a note of November 3rd, 1911, from the French ambassador in Washington to the United States Secretary of State, reference was made to the Franco-German Convention. It was declared that France would use her good offices with the Moroccan government in order to prevent any differential treatment of the subjects of the powers, in another note from the French ambassador to the Secretary of State dated November 14, 1918. Okay. It was declared that the benefit of commercial equality in Morocco results not only from the most favored nation clause, but also from the clause of economic equality, which is inserted in the Act of Algiers and reproduced in the Franco-German Convention of 1911. Okay. These various facts show that commercial or economic equality in Morocco was assured to the United States, not only by Morocco, right, but also by France as the protecting state. It may be asked whether France, in spite of her position as the protector of Morocco, is herself subject to this principle of equality and cannot enjoy commercial economic privileges which are not equally enjoyed by the United States. It is not disputed by the French government that Morocco, even under the protectorate, has retained its personality as a state in international law. The rights of France and Morocco are defined by the Protectorate Treaty of 1912. In economic matters, France is accorded France is accorded no privileged position in Morocco. Such a privileged position would not be compatible with the principle of economic liberty without any inequality on which the Act of Algiers is based. This was confirmed by the above mentioned note from the French ambassador in Washington of November 14, 1918, where it is stated that by virtue of the clause of economic equality inserted in the Act of Algiers, other states have preserved their right to enjoy such equity. Mimi v. Aves de la Precedence Protectoris, and that the United States can therefore not only recognize French courts in Morocco, but also give up in the French zone the enjoyment of all privileges following from capital relations without thereby losing their advantage. It follows from the above mentioned considerations that the provisions of the decree of December 30 of 1948 contravene the rights which the United States has acquired under the Act of Algiers, because they discriminate between imports from France and other parts of the French Union on the one hand and imports from the United States on the other. France was exempt from control of imports without allocations of currency, while the United States was subjected to such control. This differential treatment was not compatible with the Act of Algiers, by virtue of which the United States can claim to be treated as favorable as France as far as economic matters in Morocco are concerned. The conclusion can also be derived from the treaty between the United States and Morocco of September 16th, 1836, Article 24, where it is declared that whatever indulgence in trade or otherwise shall be granted to any of the Christian powers, the citizens of the United States shall be equally entitled to them, having regard to the conclusion already arrived at on the basis of the Act of Algiers. The court will limit itself to stating as its opinion that the United States, by virtue of the most favored nation clause, has the right to object to any discrimination in favor of France in the matter of imports into the French zone of Morocco. See? You see how that plays more? It's like they're using your favored nation clause, they're usurping your stuff. They're using it because there's no representation for the Moors anymore, because everybody has fell back into, a religious play, okay, and singing Noble Drew Ali hymns and stuff. So, and wearing capes, and they ain't really no superheroes. They ain't saving nothing. They just got a cape on, flogging and stunting. Huh? So that's what it is. Okay. And they knew this. They know this stuff. Okay. They know this stuff. So what these people are doing, more is like what they doing. See, and now the court will now consider the extent of consular jurisdiction of the United States of America in the French zone of Morocco. The French submission in this regard reads as follows: that the privileges of the nationals of the United States of America in Morocco are only those which result from the text of Articles 20 and 21 of the Treaty of September 16, 1836, and that since the most favored nation clause contained in Article 24 of the said treaty can no longer be invoked by the United States in the present state of the international obligations of the Sharifian Empire, there is nothing to justify the granting to the nationals of the United States of preferential treatment, which would be contrary to the provisions of the treaties. The United States submission concerning consular jurisdiction reads as follows: the jurisdiction conferred upon the United States by the treaties of 1787 and 1836 was jurisdiction, civil and criminal, in all cases arising between American citizens. In addition, the United States acquired in Morocco jurisdiction in all cases in which an American citizen or protege was defended through the effect of the most favored nation and through custom and usage. Such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone of Morocco. See, look at that. Now, such jurisdiction has never been renounced expressly or impededly by the United States because they already know they can't relinquish that jurisdiction because they already have nationals here that are Moors. And that's why they want to keep you up under a label as Negro, Black, and Colored. Okay? Because that's the secret. Okay? That's what's keeping them in your land for this long because they're claiming to be you. They're claiming to be American citizens, right? American nationals, which they are not. They are United States citizens. That's it. They are not Ameris. They are not Maoris. They're not Al Americanos. Okay, they're not that. They are foreigners that came here 5 generations ago, probably 4. Okay, all right. And such jurisdiction has never been renounced expressly or impededly by the United States. It is common ground between parties that the present dispute is limited to the French zone of Morocco. It is on this ground that the judgment of 27,852 U.S. nationals in Morocco, it has been argued that the court cannot therefore pronounce upon the legal situation in other parts of Morocco in order to consider the extent of the rights of the United States relating to consular jurisdiction. It has been necessary to examine the groups of treaties. The first group includes the bilateral treaties of Morocco with France, the Netherlands, Great Britain, right, Denmark, Spain, the United States, Sardinia, Australia, Belgium, and Germany, which cover the period from 1631 to 1892. Okay, the treaties which were largely concerned with commerce, including the rights and privileges of foreign traders in Morocco, dealt with the question of consular jurisdiction in 3 different ways. 1, certain of the treaties included specific and comprehensive grants of rights of consular jurisdictions to the powers concerned, e.g., the treaties with Great Britain of 1856 and with Spain of 1799 and 1861. Certain, right, of the treaties made strictly limited grants of privileges with regard to consular jurisdiction, e.g., the treaties with the United States of 1787 and 1836. There were other treaties which did not define in specific terms the treaty rights granted by Morocco, but instead granted to the foreign nations through the device of most favored nation clauses. The advantages and privileges already granted or to be granted to other nations. See, because once they came into conformity with other unions and nations, they usurped yours and used it for themselves. This is a common element to be found in the most favored nation clause, which have brought about and maintained a situation in which there could be no discrimination as between any of the powers in Morocco, regardless of specific grants or treaty rights. When the most extensive privileges as regard consular jurisdiction were granted by Morocco to Great Britain in 1856 and to Spain in 1861, this ensured automatically and immediately to the benefit of the other powers by virtue of the operation of the most favored nation clauses, right? Because the second group consisted of multilateral treaties, the Madrid Convention of 1886 and the Act of Algiers of 1906. The method of relying on individual action by interest powers equalized by the operation of the most favored nation clause had led to abuse, and it had become necessary not merely to ensure economic liberty without discrimination, but also to impose an element of restraint upon the powers and to take steps to render possible the development of Morocco into a modern state. According, the rights of protection were restricted and some of the limitations on the powers of the Sultan as regards foreigners, which had resulted from the provisions of the earlier bilateral treaties were abated. The possibility of abuse in the exercise by Morocco of the powers thus extended was taken care of by reserving an element of supervision and control in the diplomatic body at Tangier. Okay. The third group of treaties concerned the establishment of the protectorate. It included the agreements which preceded the assumption by France of a protectorate over Morocco. See? And the Treaty of Fez of 1812. Under this treaty, Morocco remained a sovereign state, but it made an arrangement of a contractual character whereby France undertook to exercise certain sovereign powers in the name and on behalf of Morocco. See, that's why we have the treason that we have now. You have all these Khazars that's portraying to be Moroccans, all right, with the French, right, with these European Yorbos, okay, that all usurp the Moorish provisions. Okay, the Prophet was the one who reiterated and brought everything back to us. So once he left, they swapped everything around. Then act like none of this shit happened. See what I'm saying? Oh, the Prophet didn't do that. He didn't bring that. That's why they want to say France is a Moroccan and then it's Morocco and all this, that, and the third. It's not. It says it right here. This is American. This is the United States Corporation document that I'm reading from. All right. It says right here, under this treaty, Morocco remained a sovereign state, which you're not supposed to be a sovereign state. You're supposed to be an empire. See, they already playing games with this sovereign state shit. See, this is how they play games. Okay? Now, a contractual character whereby France undertook to exercise certain sovereign powers. So why did they take to exercise certain sovereign powers? Because they are dividing the sovereign powers amongst themselves. Okay, and keeping the Moors that they call Negro, colored, Black, African American, Hispanic, etc. out of it. That's why. Okay, that's why. So anything else, okay, will be hard for these people to even look at. You understand? Because they don't understand what's really going on out here as far as what is law, what pertaining to the situation that the Moors are in. Okay, all these people in these temples that's sitting up here talking about the Prophet didn't bring this, and they mixing all this sovereign citizen talk into our movement. You see what I'm saying? They cannot mix sovereign citizen stuff into our movement because that's an oxymoron. All that is oxymoron. Okay, but what they do is they get the Masons, all right, that been studying the Moorish science, okay, and they go get them, and then they buy off Moors who's real astute in this, and then they turn them, okay, and then they go to talk against what the Prophet brought to keep Moors in a mental slavery. That's the whole scheme of things, is to keep Moors out of being who they are. They want to keep you as a Negro. They want to keep you as a color. They want to keep you as a Black, an African American. That's their whole makeup. That playing games with our mindset. Okay, so France undertook to exercise certain sovereign powers in the name and on behalf of Morocco, and in the principle, all of the international relations of Morocco, France, in the exercise of this function is bound not only by the provisions of the Treaty of Fez, but also by all treaty obligations to which Morocco had been subject before the protectorate, and which have not since been terminated or suspended by arrangement with the interested states. So they're telling you right there, this is all interested with the states. This is all of them doubling up your pot. They are taking control in certain jurisdictions over your empire. Okay, all right. The establishment of the protectorate and the organization of the tribunals of the protectorate, which guarantee judicial equality, right, to foreigners, brought about a situation essentially different from that which had led to the establishment of consular jurisdictions. Under the early treaties, according to France, initiated negotiations designed to bring about the renunciations, right? They want to renunciation of the regime of what? Capitulations, what? By the powers exercised in consular jurisdictions in the French zone. Why they want to do that? Because then, you know, they want to do that so they don't have Moors can come and fight for their rights, because they are usurping the Moors' powers. That's just like when the United States relinquished the jurisdiction, you know, the courts over here, the council of courts over here. They supposed to have a council court. All Moors supposed to be demanding council courts. All Moors. That's what we're supposed to be getting together now. Moors need to be getting together, having a convention, and finding a way to enforce our consular jurisdictions over again. That's what we need to be working on. Okay? So, now, the French submissions, and based upon the treaty between the United States and Morocco on September 16th of 1836, and it is common ground between the parties that the United States is entitled to exercise consular jurisdictions in the case of disputes arising between its citizens or proteges. There is therefore no doubt as to the existence of consular jurisdiction in this case. The only question to decide is the extent of that jurisdiction in the year 1950, when the application was filed. That's when 7 years after the kingdom was formed, 1957. The first point raised by the submission relates to the scope of the jurisdictional clauses of the Treaty of 1836, which read as follows. Article 20, if any of the citizens of the United States or any persons under their protection shall have any dispute with each other, the council shall decide between the parties. And whenever the council shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. Okay? Now, here it goes. For people who don't know, Article 21, if a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, okay, the law of the country shall take place and equal justice shall be rendered, the council assisting at the trial, and if any delinquent shall make his escape, the council shall not be answerable for him in any manner whatsoever. Okay? Okay? I'm going to read that over again. Because plainly, these people don't get what the United States Corporation did with the assistance of all these other people divvying up the Moorish Empire, okay, provisions that's supposed to be here as nationals in our own land, not going up under naturalization. The Naturalization Act is treasonous. Okay? That's usurping your sovereignty up under a United States jurisdiction. Okay? That's usurping your American citizenship. All right? Sovereignty. All right? There are foreigners. They don't belong here. Okay? I don't care what they say. I don't care how they say it. or whatever. They're 5 generations away from here. Now, I'm going to say it again. Article 21. If a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place, and equal justice shall be rendered. The counsel assisting at the trial, and if any delinquent shall make his escape, the counsel shall not be answerable for him in any manner whatever. It is argued that Article 20 should be construed as giving counselor jurisdiction over all disputes, civil and criminal, between United States citizens and proteges. France, on the other hand, contends that the word dispute is limited to civil cases. No, the fuck it's not. It deals with criminal and civil and international law. Okay, that's why consular courts need to be set up by the European. Okay, anything else will be treason. It really is treason on the United States because they're supposed to have this. They are the ones who relinquished it. They are the one who did away with the League of Nations. They supposed to be held accountable. Now, okay. Now the Treaty of 1836, okay, right? And now we're gonna look at this. It is argued that Article 20 should be construed as giving consular jurisdiction over all disputes, civil and criminal, between United States citizens and proteges. France, on the other hand, contends that the word dispute is limited to civil cases. It has been argued that this word is ordinary and natural sense would be confined to civil disputes, and that crimes are offenses against the state and not disputed between private individuals. Which no, because now they dividend your capacity and your form. Private individuals, see, that's what they do. They try to put private in and all this, that, and the third. Okay. Private individuals still doesn't matter the fact of the rules and the regulations that was already set in this formality for Moors. Because you're not Moors. That's why you want to do it on the private side. You're not a Moor. So that's why they had to do all this. That's why they got to go into a private capacity to do certain laws. You see what I'm saying? Because they can't, in other ways, they wouldn't be able to do it as in their regular capacity because they're not Moorish. Okay? The Treaty of 1836 replaced an earlier treaty between the United States and Morocco, which was, concluded in 1787. The two treaties was substantially identical in terms, and Articles 20 and 21 are the same in both, accordingly in construing the provisions of Article 20, and in particular the expression shall have any dispute with each other. It is necessary to take into account the meaning of the word dispute at the time when the two treaties were concluded. For the purpose, it is possible to look at the way in which the word dispute or its French counterpart was used in the different treaties concluded by Morocco, e.g. with France in 1631 and 1682, with Great Britain in 1721, 1750, 1751, 1760, and 1801. It is clear that in these instances, the word was used to cover both civil and criminal disputes. See? I just told you that. Now, it is also necessary to take into account that at the times of these two treaties, the clear-cut distinction between civil and criminal matters had not yet been developed in Morocco. Accordingly, it is necessary to construe the word dispute as used in Article 20 as referring to both to civil disputes and to criminal disputes, insofar as they relate to breaches of the criminal law committed by the United States citizens or their protege upon another United States citizen or protege. So that means you United States people that's been doing these laws against Moors, okay, and has been acting in our capacity need to be held accountable for what you have been doing, treason. You cut off our lineage, you cut off our way to, bring ourselves into our own. Okay? So that's why you have the SPLC calling people sovereign citizens. The second point arises out of the United States submission that consular jurisdiction was acquired in all cases in which an American citizen or protege was defended through the effect of the most favored nation clause and through customs and usage, and that such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone and has never been renounced expressly or impededly by the United States. So that means that you still have your sovereignty, Morris. They just not making you a way to express your rights. They did away with your consular courts. Okay. It is necessary to give special attention to the most favored nation clause of the United States Treaty of 1836. There were two grants of most favored nation treatment. Article 14 provides the commerce with the United States shall be on the same footing as it is the commerce with Spain, or as that with the most favored nation for the time being, and their citizens shall be respected and esteemed and have full liberty to pass and repass our country and seaports whenever they please without interruption. Article 24 deals with the contingencies of war, but it contains a final sentence, and it is further declared that whenever indulgence in trade or otherwise shall be granted to any of the Christian powers, the citizens of the United States shall be equally entitled to them. So why are we not entitled to our stuff, Morris? Why are we not entitled to our rights? Why are we not entitled to, us being Moors here and our nationality? Why are we not exempt of these taxes of the United States that be putting upon our hands? But the United States are exempt when they're doing trade and commerce. And they're using our favored nation clause, which is supposed to be applied to Moors, not them. Specifically, it's only favorable through them because they are United States citizens, and we're supposed to be the ones that are really in control, not them. Okay, they effects come after. They get the privileges, so whatever we get, they get too. It says it right here. But why are they cutting us off from what? Because they are usurping it and they're using it for themselves. Anyway, the articles entitled the United States to invoke the provisions of other treaties related to the capitulatory regime. The most extensive privileges in the matter of consular jurisdiction granted by Morocco were those which were contained in the General Treaty with Great Britain of 1856 and in the Treaty of Commerce and Navigation with Spain of 1861. Under the provisions of Article 9 of the British Treaty, there was a grant of consular jurisdiction in all cases, civil and criminal, with British nationals were defendants. Similarly, in Articles 9, 10, 11 of the Spanish Treaty of 1861, civil and criminal jurisdiction. So they got treaties on both sides. They got the treaties for the British Moors and they got the treaties for the Moroccan Moors on both sides. Four cases in which Spanish nationals were defendants. So that's the Spanish Inquisition right there. They defendants, so they're the ones usurping you out your shit. According to the United States acquired by virtue of the most favored nation clause, civil and criminal consular jurisdiction in all cases in which United States nationals were defendants, right? The controversy between the parties with regard to consular jurisdiction resulted from the renunciation of capitulatory rights and privileges by Spain in 1914 and by Great Britain in 1937. The renunciation by Spain in 1914 had no immediate effect upon the United States position because it was still possible to invoke the provisions of the General Treaty with Great Britain of 1856 after 1937. However, no power other than the United States have exercise consular jurisdiction in the French zone of Morocco, and none has been entitled to exercise such jurisdiction. So the United States is exercising all your consular jurisdictions in other countries. That's what they're doing. And they took away your consular court. Where's your consular court? Where's the consular court right here? Where is it? But they got them in all other countries though, right? But not here. Not here in the mainland, where the real nationals is at. Oh, okay. All right. Okay. Provisions of the General Treaty with the Great Britain of blah, blah, blah. And then France contends, okay, we're gonna put right here 1937, however, no power other than the United States have exercised consular jurisdiction. Okay, I'm gonna read that again. 1937, however, no power other than the United States has exercised consular jurisdiction in the French zone of Morocco. So it's the French, right, and United States, right? That's duping, and other European unions helping people. Okay. The United States has not been entitled other through the operation of the most favored nation clause of the Treaty of 1836 or by virtue of the provisions of any other treaty to exercise consular jurisdiction. Okay. So, judgment of the 27, right, 8th of 52 U.S. nationals in Morocco, beyond those cases which are covered by the provisions of Articles 20 and 21 of the Treaty of 1836, United States submission is based upon a series of contentions which must be dealt with in turn. The first contention is based upon Article 17 of the Madrid Convention of 1886, right? No, 1880, which reads as follows. The right to the treatment of the most favored nation is recognized by Morocco as belonging to all the powers represented at the Madrid Conference. Even if it could be assumed that Article 17 operated as a general grant of most favored nation rights to the United States and was not confined to the matters dealt with in the Madrid Convention. Okay? It would not follow that the United States is entitled to continue to invoke the provisions of the British and Spanish treaties after they have ceased to be operative as between Morocco and the two countries in question. The Convention of the United States is based upon the view that most favored nation clause contained in treaties with countries like Morocco must be given a different construction from that which is accorded to similar clauses in treaties with other countries. Two special considerations need to be taken into account. The first consideration depends upon the principle of a personal law and the history of the old conflict between two concepts of law and jurisdiction, the one based upon persons and the other upon territory. The right of consular jurisdiction was designed to provide for a situation in which Moroccan law was essentially personal in character and could not be applied to foreigners, right? Right? That's what they wanted in scope. The second consideration was based on the view that the most favored nation clause in treaties made with countries like Morocco should be regarded as a form of drafting by reference rather than as a method for the establishment and maintenance of equality of treatment without discrimination among the various countries concerned. According to this view, right of privileges with a country was entitled to invoke by virtue of a most favored nation clause and which were in existence at the date of its coming into force would be incorporated permanently by reference and enjoyed and exercised even after the abrogation of the treaty provisions from which they had been derived. From either point of view, this contention is inconsistent with the intentions of the parties to the treaties now in question. This is shown both by the wording of the particular treaties and by the general treaty patterns, which emerges from an examination of the treaties made by Morocco with France, the Netherlands, Great Britain, Denmark, Spain, United States, Sardinia, Australia, Belgium, and Germany over the period from 1631 to 1892. These treaties showed that the intention of the most favored nation clause was to establish and to maintain at all times fundamental equality, right, equity without discrimination among all of the countries concerned. Further, the provisions of Article 17 of the Madrid Convention, regardless of their scope, were clearly based on the maintenance of what? Equity. Okay? Equality. The contention would therefore turn contrary to the principle of equality, and it would perpetuate discrimination. It cannot support the submission of the United States regarding the extent of the council jurisdiction in the French zone. See? The second contention of the United States is based upon the geographically limited character of the renunciation of consular jurisdiction by Great Britain. This was restricted in its scope to the French zone. It has been claimed on behalf of the United States that Great Britain retained its jurisdictional rights in the Spanish zone, and it has been argued that the United States, which still treats Morocco as a single country, is entitled under the Most Favored Nation Clause and Article 24 of its treaty to the same jurisdictional rights which Great Britain to this day exercises in a part of Morocco by virtue of the treaty of 1856. See, it's the same shit. They playing games. The court is not called upon to determine the exercise or extent of the jurisdictional rights of Great Britain in Spanish zone. It is sufficient this argument on the ground it would lead to a position in which the United States was entitled to exercise consular jurisdiction in the French zone, notwithstanding the loss of the right by Great Britain. This result would be contrary to the intention of the Most Favored Nation Clause to establish and maintain at all times fundamentally equality without discrimination as between the countries concerned. Reliance has also been placed upon the position of France and French nationals as regards the new tribunals of the protectorate, which have been established for the purpose of exercising jurisdiction over foreigners and applying Moroccan laws to them in the French zone. These tribunals have been constituted, right, constituted with French aid and under French direction and supervision. It is suggested that these are in reality consular courts and that the United States is entitled to be placed in this regard in a position of equality with France. But the tribunals of the protectorate in the French zone are not in any sense consular courts. They are Moroccan courts organized on French models and standards, affording guarantees of judicial equality to foreigners, according to the court, cannot accept the contention. Look at that, Morris. So these people, they went and took your laws, your sovereignty, and they made it into a form of Moroccan laws that's gonna, favor, the damn foreigners. Just like over here in the United States, corporation, they have usurped our judicial system. So now they are favoring the rich people, okay, and the Europeans that's in control. Because if you're poor and you're European, they still fry your ass, so they don't care. So whoever they make their laws for, whoever they want to be, give them the favorite nation clause to, that's who they give it to, Morris. So we want to act like that this is not going on, huh? Y'all want to really act like that this is not going on, and y'all want to get mad with Morris when we try to tell y'all what's really going on. Y'all want the truth, but y'all really don't want the truth. Because once the truth has been admitted, then y'all have to get up there and really do something about your damn shit. Y'all gonna have to fight. Y'all gonna have to get up and do something. Y'all can't just be laying around here anymore and talking smack and not putting no effort behind whatever you're doing. Morris? So really, what's really the deal, Morris? Huh? What's really the deal? So now we're looking at the scope and we're measuring it. The third contention of the United States is based upon the nature of the arrangements which led to the termination of Spanish consular jurisdictions in the French zone, okay, by a convention between France and Spain of November 27, 1912. Provisions was made for the exercise by Spain of special rights and privileges in the Spanish zone by a bilateral declaration between France and Spain of March 7, 1914. Spain surrendered its jurisdictional and other extraterritorial rights in the French zone, and provision was made for the subsequent surrender by France of similar rights in the Spanish zone. This was accomplished by a bilateral declaration between France and Spain of November 17 of the same year. The United States contends that as both conventions of 1912 and the declarations of 1914 were agreements between France and Spain, and as Morocco was not named as a party to either agreement, the rights of Spain under the early provisions still exist de jure, notwithstanding that there may be a de facto situation which temporarily prevents their exercise. So, what people don't get, Morris? What people don't get, huh? De facto, they're doing things in de facto mode. So how they gonna invoke anything? How? So, okay, now Spain has been unable to insist on the right to exercise consular jurisdiction in the French zone since 1914. The rights which the United States would be entitled to invoke by virtue of the most favored nation clause would therefore not include the right to exercise consular jurisdiction in the year 1950. They would be what? Limited to the contingent right of reestablishing consular jurisdictions at some later date in the event of France and Spain abrogating the agreements is made by the Convention of 1912 and the Declaration of 1914. France contends that these agreements were concluded pursuant to the power which Morocco conferred in France by the provisions of the Treaty of Fez of 1912. The general terms of Article 5 and 6 were broad enough to give to France the conduct of the international relations of Morocco, including the exercise of the treaty making power. The convention and the declarations must therefore be regarded as agreements made by a protecting power within the scope of its authority touching the affairs of and intended to bind the protected state, as is made clear by the third paragraph of Article 1 of the Treaty of Fez of 1912, which provided that the government of the Republic will come to an understanding with the Spanish government regarding the interests which the latter, right, government has in virtue of its geographical position and territorial possessions on the Moroccan coast. In these circumstances, it is necessary to hold that these arrangements bond and endure, right, to inure to judgment, okay, the benefit of Morocco, that the Spanish rights as regarded consular jurisdiction came to an end, de jure as well as de facto. Okay, so they had to reestablish their jurisdictional provisions more, because they said right here the benefit of Morocco and that the Spanish rights as regards consular jurisdiction came to an end. Okay, de jure as de facto. So that means that whatever the scope that these people has done, you know what I mean, they gotta edify the council of courts to straighten everything out. Okay, it is necessary to deal with another aspect of this question, which arises out of the wording of the declaration made by France and Spain on March 7, 1914. This declaration contained the following provisions: taking into consideration the guarantees of judicial equality offered to foreigners by the French tribunals of the Protectorate, His Catholic Majesty government renounces claiming for its councils, its subjects, and its establishment in the French zone of the Sharifian Empire all the rights and privileges arising out of the regime of the capitulations, the capitulations regime of the capitulations. So far as the government of the French Republic is concerned, it binds itself to renounce equally the rights and privileges existing in the favor of its councils and subjects and its establishment in the Spanish zone as soon as the Spanish tribunals are established in that said zone. Okay, the declaration whereby France complied with the above undertaking was made on November 17, 1914, and included the following paragraph. Taking into consideration the guarantees of judicial equality offered to foreigners by the Spanish tribunals in the protectorate, the government of the French Republic hereby renounces claiming for its councils, its subjects, and its establishment in the Spanish zone of the Sharifa Empire all the rights and privileges arising out of the regime of the capitulations. So that means that they 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 took each zone and everybody took on their own zone. They relinquished those jurisdictions, consulate jurisdictions, and they all, made parties to foreigners. Okay, and they just threw down the Sharifin way. They threw down the Moorish way. Like, forget the Moorish way, right? Okay, right. So now, after they renounced claiming, and the question has arisen whether these words were intended as a surrender or renunciation of all the rights and privileges arising out of the capitulatory regime, or whether they must be considered as temporary undertakings not to claim those rights or privileges so long as the guarantees for judicial equality are maintained in French zone by tribunals of the protectorate, and so long as the corresponding guarantees are maintained in the Spanish zone. The question is academic rather than practical. Even if the words in question should be construed as meaning a temporary undertaking not to claim the rights and privileges, the fact remains that Spain in 1959, as a result of these undertakings, was not entitled to exercise consular jurisdiction in the French zone. It follows that the United States would be equally not entitled to exercise such jurisdiction in the French zone in the year 1950. Okay? Nevertheless, it is necessary for the court to examine these declarations in order to determine what the parties had in mind when they used the words in question. These parties in both declarations, right, are used in the expression taking into consideration the guarantees of judicial equality. These are words which, if given their ordinary and natural meaning, state the consideration which led to the making of the surrender. But they are not words which would normally be used if it was intended to make a conditional surrender. The court is of opinion that the words renounce a reclaimer must be regarded as an out and out renunciation of the capitulatory rights and privileges. This view is confirmed by the taking into account the declarations and other agreements made by France with other interested powers designed to bring about the surrender of their jurisdictional and other extraterritorial rights in the French zone. The two declarations made by France and Spain in 1914 show that they both regarded the expression renounce a reclaimer as equivalent to a renunciation of the rights in question. In the declaration of March 7, 1914, the French government bound itself to renounce equally the rights and privileges. In the later declaration of November 17, 1914, France gave effect to this obligation by using the expression renounce a reclaimer. It is a clear, therefore, that both France and Spain regarded this expression as proper for bringing about a complete surrender or renunciation of the rights and privileges in question. On July 31st, 1916, the French ambassador at Washington sent to the Secretary of State of the United States the text of the declaration signed with reference to the abrogation of capitulations and French zone of Morocco by all the powers signatory of the Algiers Conference and by the South American republics. And the text thus transmitted the expression used in English was relinquished its claim to all the rights and privileges growing out of that capitulation regime. It is thus clear that at the date long before the present dispute had arisen, France regarded the expression relinquish its claim, or in other words, renounce a reclaimer, as bringing about the abrogation of the privileges in question. The declaration made by France and Spain of March 7, 1914 was one of a series of agreements negotiated by France with more than 20 foreign states for the surrender of their jurisdictional and other um, extraterritorial rights, so far as concern the French zone of Morocco. At least 17 of these agreements use the expression renounce a reclaimer as a means of bringing about a complete abrogation of all rights and privileges arising out of the regime of capitulations, okay, or capitulations. They are referred to in the counter memorial in the following words: for the surrender of their jurisdictional and other extraterritorial rights, and again for the renunciation of extraterritorial rights. Further, all of the states which had signed these agreements abandoned forthwith the exercise of consular jurisdiction or other contemporary rights of privileges in the French zone. In these circumstances, it is necessary to conclude that the Spanish Declaration of March 7, 1914 brought about the surrender of renunciation of all Spanish jurisdictional or other extraterritorial rights in the French zone, and an abrogation of those provisions of the Spanish Treaty of 1861, which concern the rights and privileges arising out of the regime of the capitulations. The court therefore cannot accept the contention that the United States is entitled by virtue of the most favored nation clause to invoke in respect of the French zone those provisions of the Spanish Treaty of 1861 which concern consular jurisdiction. See, you need consular jurisdiction. The fourth contention of the United States is that the extensive consular jurisdiction as it existed in Morocco in the year 1880 was recognized and confirmed by the provisions of the Madrid Convention, and that the United States, as a party to that convention, right, thereby acquired an autonomous right to the exercise of such jurisdiction independently of the operation of the most favored nation clause. There can be no doubt that the exercise of consular jurisdiction in Morocco in the year 1880 was general, or that the convention, right, presupposed the existence of such jurisdiction. It dealt with the special position of proteges and contained provisions for the exercise of jurisdiction with regard to them. On the other hand, it is equally clear that there were no provisions of the convention which expressly brought about a confirmation of the then existing system of consular jurisdiction or its establishment as an independent and autonomous right. Okay, I'm gonna say that again. Okay. On the other hand, it is equally clear that there were no provisions of the convention which expressly brought about a confirmation of the then existing system of consular jurisdiction or its establishment as an independent and autonomous right. The purpose and objects of this convention were stated in its preamble in the following words: the necessity of establishing on fixed and uniform basis the exercises of the right of protection in Morocco and of settle certain questions connected therewithin. In these circumstances, the court cannot adopt a construction by implication of the provisions of the Madrid Convention, which would go beyond the scope of its declared purposes and objects. Further, this contention would involve radical changes and additions to the provisions of the convention. The court, in its opinion, interpretation of peace treaties, second phase, ICJ reports 1950, page 229, stated it is the only duty of the court to interpret the treaties, not to revise them. Okay. The fifth contention of the United States is that the consular jurisdiction in Morocco was recognized and confirmed by various provisions of the Act of Algiers, and that the United States acquired an autonomous right to exercise such jurisdiction independently of the operation of the most favored nation clause. So why would they do that? Why would they do that? Why would they? Why would they? Why would they do that? Huh? I'm gonna read it again, Morris. The fifth contention of the United States and that the council jurisdiction in Morocco was recognized and confirmed by various provisions of the Act of Algiers, and that the United States acquired an autonomous right to exercise such jurisdiction independently of the operation of the most favored nation clauses. In 1906, the 12 powers of Algiers all exercised contemporary, com, yeah, co- capitulatory rights and privileges to the extent that they were prescribed either by the General Treaty with Great Britain or by Great Britain of 1856 or by the Spanish Treaty of 1861. They did so by virtue of direct treaty grant, as in the case of Great Britain or Spain, or by virtue of most favored nation clauses, as in the case of the United States, or without treaty rights, but with the consent or acquiescence of Morocco, as in the case of certain other states. Accordingly, the Act of Algiers presupposed the existence of the regime of the capitulations, including the rights of consular jurisdiction, and many of its provisions assigned particular functions to the then existing consular tribunals. Okay, reference has been made in the course of the argument to Articles 19, 23, 24, 25, 29, 45, 59, 80, 81, 87, 91, 101, 102, and 119. For example, Chapter 5, which deal with the customs of the empire and the repressions of fraud and smuggling, contains Article 102 provides every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdictions and on Moorish subjects by Sharifian jurisdiction. So what are they doing, Morris? Hmm? Hmm? What are they doing? Now, we want to know what they're doing. I want to know. Okay? Now, I want to put this in here. Every state, country, and local tribunal of the Honorable United States of America and Supreme Court and Congress, the International Court of Justice, all free national governments under their free national constitution, republics, monarchies, family of nations, indigenous people of the earth, the world sovereign orders of the Hindu, Hebrew, Christian, Muslim, and every country, kingdom, indigenous tribes, and all members of the human family. All right, that's who all those treaties and favorable nation clauses need to be applied to. Okay, the prophet was prepared by the great God Allah to warn my people to repent from their sinful ways and go back to the state of mind of their forefathers, divine and national principle, that they will be law abiders and receive their divine rights as nationals, according to the free national constitution that was prepared for all free national beings. They are to claim their own free national name and religion. There is but one issue for them to be recognized by the government and nations of the earth, and that comes only through the connection of the Moorish divine national movement, which is incorporated in the government and recognized by all other nations of the world. And through it, they and their children can receive their divine rights, unmolested by other citizens, that they can cast a free national ballot at the polls under the free national constitution of the state's government, and not under a granted privilege as has been the existing condition for many generations. Okay? Money doesn't make the man. It is the free national standards and power that make the man and the nation. Okay? So you who doubt whether I, the prophet, and my principles are right for the redemption of my people, go to those who know the law in the city hall among the officials in your government and ask them under an intelligent tone, and they will be glad to render you a favorable reply, for they are glad to see me bring you out of the darkness into light. Okay. Um, the wealth of all national governments, gold, silver, and commerce belong to the citizens alone, and without your national citizenship by name and appellation and principles, you have no true wealth. And I am hereby calling on all true citizens that stand for a national free government and the enforcement of the Constitution to help me in my missionary work, because I need all support from all true American citizens, which are American nationals of the United States of America. Help me to save my people who have fallen from the constitutional laws of the government. I am dependent on your support to get them back to the constitutional fold again, that they will learn to love instead of hate and will live according to love, truth, peace, freedom, and justice, supporting our free national Constitution of the United States of America. Now, we don't have a democracy here. We have a form of republic here. So if anybody talking Democrat stuff like that, democracy, that's treason. Okay, all right. I love my people, and they desire their unity and mind back to their own free national and divine standard, because day by day they have been violating the national and constitutional laws of their government by claiming names and principles that are unconstitutional. If Italians, Greeks, English, Chinese, Japanese, Turks, and Arabians are forced to proclaim their free national name and religion before the constitutional government of the United States of America, it is no more than right that the law should be enforced upon all other American citizens alike. Now, why? Why is this Italians, Greeks, English, right? Chinese, Japanese, Turks, and Arabians? Because all of them are in cahoots with the United States. Okay, that's helping usurp your national principles and your nationality. Like running around here calling you Negroes, blacks, and colored. And then those are European Eurobos hybrids that all coming up under those nationalities to do so. Okay, like I said, Khazars. All right. Now, you have to understand, before the constitutional government of the United States of America, it is no more than right that the law should be enforced upon all other American citizens alike. In all other governments, when a man is born and raised there and asks for his national descent name, and if he fails to give it, he is misused, imprisoned, or exiled. Any group of people that fail to answer up to the constitutional standards of law by name and principles, because to be a citizen of any government, you must claim your national descent name, because they place their trust upon issues and names formed by their forefathers. The word Negro alludes into the Latin language to the word nigger, the same as the word colored alludes to anything that is painted, varnished, and dyed. And every nation must bear a national descent name of their forefathers, because honoring thy fathers and thy mothers, your days will be lengthened upon this earth. These names have never been recognized by any true American citizen of this day. Though your free national name, you are known and recognized by said national government in which you live. The 14th and 15th Amendments brought the North and South in unit, placing the Southerners who were at that time without power within the Constitution body of power. And at that time, 1865, the free national constitutional law that was enforced since 1774 declared all men equal and free. And if all men are declared by the free national constitution to be free and equal, since that the Constitution has never changed, there is no need for the application of the 14th and 15th Amendments for the salvation of our people and citizens. So there isn't but one supreme issue for my people to use to redeem that which was lost, and that is through the above statement. Then the lion and the lamb can lay down together in the yonder hills, and neither will be harmed. because love, truth, peace, freedom, and justice will be reigning in this land. In those days, the United States will be one of the greatest civilized and prosperous governments of the world. But if the worst is yet to come, because the great God of the universe is not pleased with the works that are being performed in North America, which is Morocco, by my people, and thus great sin must be removed from the land to save it from the enormous earthquakes, diseases, etc. And I, the prophet, do hereby believe that the administration of the government, being more wisely prepared by more genius citizens that believe in their free national constitution and laws through the help of such classes of citizens. The prophet truly believed that my people, the prophet truly believed that my people will find the true and divine way of their forefathers and learn to stop serving the carnal customs and merely ideas of man that have never done them any good but have always harmed them. So I, the prophet, am hereby calling aloud with a divine plea to all true American citizens to help me remove this great sin which has been committed and is being practiced by my people in the United States of America, because they know it is not the true and divine way, without understanding that they had fallen from the true light into utter darkness of sin. And there is not a nation on earth today that will recognize them socially, religiously, politically, or economically, etc., and their present condition of their endeavors, and which they themselves try to force upon a civilized world. They will not refrain from their sinful ways of action, and their deeds have brought Jim Crowism, segregation, and everything that brings harm to human beings on earth. And they fought the Southerners for all these great misuses, but I have traveled in the South and have examined conditions there, and it is the works of my people continuously practicing the things which bring dishonor, disgrace, and disrespect to any nation that lives the life. And I am hereby calling on all true American citizens for moral support and finances to help me in my great missionary work to bring my people out of darkness into marvelous light. Okay? Now, the Treaty of Peace of 1786, Louisiana Purchase Treaty of 1805, okay? The presidential pardon of Abdul Rahman Arim, okay? And the Amistad Immunity of 1841, Treaty of Guadalupe, Hidalgo in 1848, Dred Scott decision of 1836, and Asian Act of 1868. All right. The original Constitution laws, which United States do not use anymore. Okay, now comes the petition in the Moorish Science Temple of America and original constitutional law in force in 1774 to move this avertment of jurisdiction to the status of the Moorish Americans, hereby challenge the respondent, the United States Congress, United States Supreme Court, etc., to be received as the order of today's judicial business, the supreme laws of the United States and all other free national governments judicially upon. There can be no legal proceeding without the establishment of proper status and correct jurisdiction. These two pillars of law must be in place and have precedence before the adjudication of all formal and alleged offenses can be addressed. So that means that the United States has to be the ones to initiate the consular jurisdictions all over again. Okay? So the above said Supreme Court decisions combined and resolved as the laws and citizens of the United States were the lawful genesis, um, per, personifying the supreme issues of status and jurisdiction. These issues are relevant to the immediate matters of nationality, right? And manumissions of the indigenous Moorish, okay, Aboriginal to the continental breast of the North America. Here now the greatest bounds of jurisdiction and power to the wisdom in the Supreme Court of the United States is now challenged to render in written personam its constitutional jurisdiction to govern the lost and founded Aboriginal tribes of the Moorish American nation and estimated 60 million descendants. The U.S. Supreme Court, in full authority to exercise the power of the United States Constitution, joined with the entire embodiments of Congress, now have the burden of proof to any jurisdiction to justly govern the clean and pure nation of Moorish Americans present in their proper persona now before you. The uniting of this nation is the calling of our family bearing their one free national name of Moorish American. Is not being misconstrued as a religious organization, okay, confined to the United States First Amendment, nor to be confused with those denationalized in the United States 14th Amendment under the ex post facto slave labels of Negroes, blacks, and colored people, when after no jurisdiction over the Moorish Americans can be claimed and proven by the challenged sovereignty, whether spiritually, ancestrally, indigenously, politically, or legally, then both the lion and the lamb are to lay together, and neither will be harmed in this new era. They are to let the peace be still in the North American continent and the world now and forever. Now the highest court in the United States being in want of said jurisdiction and therefore without power to issue an impersonal judgment. We the free national Americans ourselves affects hereupon do hereby declare the autonomy of our Moorish American nation, our first inalienable right to be free to be ourselves, God like in his own likenesses and image, without any contradiction or subjugation. Okay, Morris? Because that's what it's all about, being a national. Okay? The time has come that every nation must worship under its own vine and fig tree, and every tongue must confess his own. Now, in accordance with the divine plan of the ages, it is mandatory for the people standing in their proper person to proclaim their free national status, thus dissolving all unauthorized political bonds and assume jurisdictions. The fallen sons and daughters of the Asiatic nation of North America, Al Marat, need to learn to love instead of hate, and to know of his higher self and lower self. This is the uniting of the Holy Quran of Mecca for teaching and instructing all Moorish Americans. The key to civilization was and is in the hands of the Asiatic nations. The Moors who were the ancient Moabites and the founders of the holy city of Mecca. The Moabites from the land of Moab, who received permission from the pharaohs of Egypt to settle and inhabit northwest Africa. They were the founders and are the true possessor of the present Moroccan Empire, with their Canaanite, Hittite, and Amorite brethren who sojourned from the land of Canaan, seeking homes. The river Nile was dredged and made by the ancient pharaohs of Egypt and other to trade with the surrounding kingdoms. Also, the Nile River was drugged by the great pharaohs of Egypt in those ancient days for trade, and it extends eastward from the river Nile westward across the Atlantic. It was used for trade and transportation. So Morris, we set up all these ancient routes. We set up all these ancient trades. We did everything. Every confiscation fine, you see what I'm saying, or penalty must be imposed on foreigners by consular jurisdiction. You know what I mean? Not not the other way around. And on more subjects by Sharifian jurisdictions too. So that means that if we violate our jurisdiction or whatever, you see what I'm saying, we'll be able to enforce our laws just as well. They'll be able to enforce their laws. You see what I'm saying? So so we won't be able. It won't be nobody um, disrespecting each other. See what I'm saying? You won't be able to just harm me. You won't be able to just rob me. You won't be able to just usurp me or throw me in your prison, or detain me unlawfully without any penalties coming down on your head. And the same thing goes for Moors. If we do anything, do anything unlawfully, you see what I'm saying, on anything on penalties, that's why the council jurisdiction course was there to 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 you know come together and agree and disagree on certain disputes. Okay. The position has been one since 1937. The position has been one in which 11 of the powers have abandoned their compulsory privileges, and their consular jurisdiction has ceased to exist. According to Morocco, has been able to make laws and to provide for their trial and punishment of offenders who are nationals of these 11 countries. These positions of the United States is different and must now be examined. Unlike the Madrid Convention, the Act of Algiers was general in its scope and was not confined to a limited problem such as that of protection. On the other hand, the interpretation of the provisions of the Act must take into account its purpose, with which are set forth at the preamble in the following words: inspired by the interest attaching itself to the reign of order of peace and prosperity in Morocco, and recognizing that the attainment thereof can only be effected by means of the introduction of reforms based upon the triple principle of the sovereignty and independence of His Majesty the Sultan, the integrity of his domains, and economic liberty without in equality. Okay, so that means that everything that the Sultan has should be added to his subject. All right. So you Moors, just got to look at it like that, man. And I'm gonna go ahead and try to, you see what I'm saying, Moors, come up out of here because I think I've been on here for a minute, and that's just how it works, Moors. Like, we have to come into a better understanding as far as our understanding, and as far as what's really going on. You see what I'm saying? So it's just, I look at it like this, Morris. For us to get somewhere, for us to really engage these people, and for us to really have our own, we have to be very studious into this, and we have to really have our own mindset as far as our studies, and putting our profit up front. You know what I mean? Because there's going to be a lot of dirty Moors out here that's going to try to usurp and going to try to come and tell lies. You see what I'm saying? So I just want y'all to understand that, and basically everything else will come. You see what I'm saying? As far as what Moors know, as far as knowledge and what we're seeking to know. You see what I'm saying? So I hope that this bill right here, you know what I mean, help people, I'm saying, come into knowing what they really need to know as far as, how stuff are, well, how stuff is ran and how things are you know played. Don't really try to give you the real scope of certain knowledge and stuff like that. They like to play games, and they don't want to really be like, they really don't want to be, they want to be clandestine. They like, and then you have these people that's playing these games. Okay, um, they're no good either. They're no good either. So I want to tell you, Morris, um, we're gonna have to try to keep things in perspective and really know what we're doing as far as, what we're trying to seek, Morris, what we're trying to do. um, Certain processes that we need to do, we need to do it correctly. We need to be competent, whatever we're doing. What I mean, don't be in such a rush and to start doing certain activities. What I mean, if you feel like you're not ready to go into those activities yet, don't beat yourself up. Give yourself some time to really know what you're doing before you start going into um into certain context of what you're trying to do, as far as as far as what you're trying to do, as far as a claim, anything you're doing, more is make sure that you have the proper scope of doing so. So I'm gonna try to get up out of here. I want to tell you more is Islam, peace, love, and light, and to next bill. Islam, Morris. Love, truth, peace, freedom, and justice, kid. Yo, travel the globe like Neo-Africaners. Bluetooth mode. Study moorish science, no need for college. My knowledge reigns supreme. 360 degrees. We on the occupation, strategize, remain patient. The colonists and Zionists, they worship Satan, but they time's up. Pray to our Lord, keep the nines up. What? Something no pressure, luck, never disrespect the feds. So you feel my hot lead, my flag Bluetooth mode. Blood that I bled, all they know is war. So they forget about the peace. When we want justice, then don't forget to bring the heat. This shit'll wreck the system in your Jeep. No surrender, no retreat. Blow the hookah in Moorish Sicily. I'm a lion, so I never roll with sheep. My style is so unique, and you know I always practice what I preach. Time to separate the strong from the weak. Cause when I'm on the battlefield, I ain't got no time for defeat. Some call me Saracen, some call me Carthaginian, some call me Blackamoor, some call me Mediterranean. I drop the knowledge for your cranium. It's the rise of the Moors. You see the turbans, we mobbing like Albanians. Who brought you libraries? Who brought you math? Who civilized you? Who showed you how to take a bath? They whitewash the past, but karma's coming and it's coming fast. 12 gauge slugs to feel the wrath. COINTELPRO try to infiltrate. It's time to lock and load, leave you with holes the size of dinner plates. Yo, to come correct, cause I'm going out for respect. Fuck your Kevlar vest, I only aim above the neck. Head to my castle in Granada, Spain. Sipping mango juice, counting loot. My retinue is not a game. Head to my castle in Granada, Spain. Sipping mango juice, counting loot. My retinue is not a game. They thought we was done after 1492. It's the rise of the Moors. Y'all know what time it is. It's on now. Get down and lay down.